Hi, everybody. It's Jim Ostrowski back with the Liberty Moving podcast. I'm just going to do a short report today. One of the differences between me and a lot of the podcasters is that I'm actually out in the real world fighting the bad guys. No offense to the other people, but again, why should you listen to me and as opposed to not listening to me? I'm out there in the trenches. Fighting every day for liberty. So I've got a couple of lawsuits going that are winding their way through the courts. One is against the lockdown. The defendants include Governor Cuomo and Letitia James, the left-wing attorney general who's suing Trump all the time. And they're actually not both defendants in the case, but also Letitia James's office is defending these cases. So let's just talk about one of those today. We're going to talk about the challenge to the New York pistol permit law, and then the next podcast I'll deal with the lockdown. They're just filed briefs. Both briefs are, I put these kinds of briefs on Scribd.com under my name. They're easy to find. So in the pistol permit case, basically, it's a long story. I'm not going to go through it, but after Heller was decided, it was obvious to me that the New York pistol permit statute, which is way more burdensome than Heller would allow, is unconstitutional. So finally got an opportunity to file suit a few years ago. It wound its way through the courts. Not my fault. There was quite a few years of delay. Among other reasons, waiting for the Supreme Court to rule in the NYSERPA case. They punted that case, and the Second Circuit then affirmed a lower court ruling that the pistol permit law was acceptable under this lesser intermediate scrutiny standard. So we just filed a petition for review en banc, which means by the whole court. So technically, the panel was 3 senior judges. There's 13 regular judges on the court. All 17 of those judges, as I understand it, can vote to rehear the case or not. There's 5 Trump judges, excuse me, 5 Trump judges on the court. We're very interested to find out where they stand on a Second Amendment case of this nature. If it's denied, we will go to the Supreme Court. We have 90 days to do that. So basically the argument that we're making is that there's an intermediate scrutiny standard, which is sort of legalese, but it essentially means that they're adopting the very lenient balancing test that Judge Breyer set forth in Heller. Judge Breyer would have held that there's no right to bear arms at all. And as a backup, he said, well, there's an intermediate, let's do a balancing test, a very lenient test. If the government can show that the law is designed to fulfill some legitimate function, blah, 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 blah. As I point out in the brief, the test is designed to basically affirm any gun control law. So it's really a disingenuous test. So ironically, the Second Circuit has adopted the dissent in Heller. This is what we argue in the brief. Now there's a recent Ninth Circuit case, Duncan versus Becerra, which struck down a ban on high-capacity magazines. Long story short, they adopted strict scrutiny, so we're claiming there's a conflict. We're also claiming that the Second Circuit's decision, which is, by the way, Libertarian Party of Erie County v. Andrew Cuomo, we're claiming that case we're appealing, contradicts Heller and McDonald in the Supreme Court. So that's the basic outline. The brief we wrote, like all of my briefs in a public interest type case, is not just filled with legalese, but kind of tries to explain to the layman what this is all about. So basically, the argument that we're making is that what we call the government tyranny argument. And a lot of the gun organizations and the big law firms are afraid to say, for whatever reason, the purpose of the Second Amendment is to deter government tyranny. So if you don't recognize that, then whatever balancing test you come up with is not going to make any sense and is going to be kind of rigged in advance against the Second Amendment. So we made this argument throughout. It was ignored by the court. It was ignored, it was ignored by the Attorney General. It was ignored by the Bloomberg amicus curiae and the Gabby Giffords amicus curiae. And the reason why they ignore it is they have no answer for it, as I explain in the brief. So we're urging the court to recognize that this is the purpose of the Second Amendment. You can't litigate Second Amendment cases without understanding the purpose, because, not to get into jurisprudence, but all language is vague or ambiguous or subject to change over time. So we always look at the purpose behind a statute or a constitutional provision or a common law principle to apply it to a particular set of facts. And it's our contention, and we say it explicitly. So why is everybody ignoring the elephant in the room, as we call it, the government tyranny argument? It's because there's no rebuttal to it. That all of these gun control Second Amendment cases, they're all based on this implied notion that the Second Amendment has something to do with, something to do with street crime, shooting a burglar. And so that's the level at which the costs and benefits of gun control laws or no gun control laws are argued. But if you say, well, no, the purpose of the Second Amendment is to deter government tyranny, and it works, as I said in my book, The Second Amendment Works, which is on Amazon. It's also free at 2anys.com, Steve Filano's group. And I present, and the book is cited in the brief. It's pretty funny to cite your own case, but hey, if somebody else wrote the book, I would have cited it, but I wrote the book. I'm certainly not going to ignore evidence in favor of our position just because it's my citation. So there's original research in there, and there's old research sort of presented in a new way. We point out that in countries where there's a lot of coups d'etats, there's very, very few civilian firearms. So again, if that's the purpose, then they're going to have a really tough time constructing whatever tests they want to formulate to knock out the Second Amendment. And I would argue that none of those tests are sufficient. And only in an extreme case, as Heller talks about, a person adjudicated mentally ill or somebody's convicted of a violent felony. Other than that, given the government tyranny argument, given the fact that an armed citizenry has these sort of very general benefits that are hard to get into the weeds about, such as deterring strong-armed burglaries like you have in England. There's very few guns. The burglars figure, well, I'll just go in when the people are home and I'll get the wallet, the purse, and the stuff in the house. So there's these very general benefits to the right to bear arms that it would be hard to figure out a test that factors that in and allows any sort of significant government regulation. So it's a way to really clobber them on a conceptual, theoretical basis, and that's why they're ignoring this. But we're gonna keep pressing the argument as boldly as we can until we get an answer to it. And so that's basically the concept of the brief. We cite R.J. Rummel, Death by Government. We're really down and dirty. We're not like trying to hide out under some hyper-technical big law firm. Don't make anybody really upset. Don't get too radical. Well, we're really radical. we've done it with a straight face. Nobody's challenged us in court. They're all afraid to challenge us. Certainly the opposing counsel. We haven't gotten any questions from the court on this at all. Just sort of, a look of, wow, we haven't heard that argument before. What do we do now? Well, the court ignored it, but we want the entire panel to not ignore it and deal with it. So this brief is on my Facebook page. It's on Scrib.com, and I'll keep you posted on the blog about it. Don't know when they'll issue a decision, and we will be going for Supreme Court review if this is denied, obviously. And maybe I'll just read a little bit of an excerpt from the brief, and then I'll close off with that, because it's, I realize getting too much of the weeds on a legal matter is not the most scintillating podcast. So let me just read the conclusion, and we'll go with that. We urge the court to rehear this case en banc for the reasons stated above, but also because of the unprecedented events of the last several months, all of which demonstrate that the plaintiff's complaint was correct, if not prophetic. Not only have we seen New York State adopt rule by executive decree erasing the state and federal constitutions in New York, but an incident of police brutality, an issue addressed at paragraphs 51 to 53 of our amended complaint, metastasized into a virtual uprising in all our major cities that the police were unable to control, resulting in death and destruction not seen since the 1960s. Neighborhoods a few blocks from the Second Circuit Courthouse were trashed. For the following reasons, the case should be reheard. The state of New York seized virtual totalitarian powers by executive decree and closed their courts to make redress almost impossible. The state of New York closed their pistol permit offices and gun stores at a time when they were releasing prisoners and reducing arrests. Public concern about police abuse continued as predicted in the complaint and arising from the killing of George Floyd in broad daylight and the injury to Martin Gugino in Buffalo, while the police were enforcing a legal curfew order of Mayor Byron Brown. Riots across the United States plagued law-abiding citizens, while the police were nowhere to be found. They were busy protecting government property, but could not prevent a pane of Constitution embossed glass from being cracked at the Robert H. Jackson Courthouse in Buffalo, New York. Still damaged as of this morning. I drove by and took a photo. Now the same forces that want to violate the right to bear arms want to abolish the police. These events confirm the central arguments of the amended complaint. So I won't read the legalese final paragraph. So that's basically it. Again, what I'm bringing to the table is, in addition to the type of stuff, the discussion of issues that you would expect in a podcast, I'm in the trenches, not only with active litigation, but also direct action projects such as the Liberty Moving Project, which you'll be hearing more about. So next podcast, I'm going to go into the lockdown brief, which is a little bit more involved, and try to give you a flavor of. It's a broad-based challenge. I'll try to at least give you a summary of the basic arguments we're making. So. Over and out from the Liberty Moving podcast, in the trenches, fighting the bad guys on a daily basis for the cause of liberty.